Do you have to give 120 days notice to terminate a tenancy if a property is being sold in California? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I got this question, a couple of them actually, this week consulting with some landlords here. They were saying, hey, they're doing some internet research on Google, and Google told them that they had to give a minimum of 120 days notice to terminate a tenancy if the property was being sold. I'm going to correct that misnomer right here. That is not the law in California, okay? And we'll talk about Ellis Act evictions, going out of business. That's a whole different thing. We're talking about terminating the tenancy, giving a tenant notice, basically. If you can terminate the tenancy, let's assume without just cause, okay, for my exempt landlords, the answer is no, absolutely not. The Civil Code provides on a month-to-month tenancy under Civil Code Section 1946 and 1946-1. 1946-1 specifies minimum of 60-day notice if a tenant has resided in a property for 1 year or greater, basically, okay? If it's under a year, it's 30 days. That's all codified in the Civil Code, okay? If you have a Section 8 tenancy, it's a minimum of 90 days. I can't quote, I believe that's in the Health and Safety Code somewhere. It's a kind of odd place, but I digress. Bottom line is, don't get your information from Google, okay? And especially nowadays, because not only do you need to know the minimum terms of how much notice you have to give the terminated tenancy, some landlords have to have just cause under California state law under the Tenants Protection Act. And if you're in a city that governs, regulates evictions, what we call eviction control, your regulations may vary. Okay, so it's good to always sit down with a landlord's attorney. I think that 120-day deal on the internet is a misunderstanding of what Civil Code 1954 reads about entering a property for sale. That is an entirely different statute. It's an entirely different set of rules. And what it's for is if you're listing your property for sale, basically, you can give your tenant a notice that the property is being listed for sale, and for 120 days afterwards, you can give your tenants oral notice that you're going to be entering the property. You have to give at least a minimum of 24 hours notice that you're going to enter the property for the purpose of showing the property to prospective buyers or actual buyers. Let's say you're trying to conduct your conduct your inspections. Can't talk today. Normally, without that carve out in the Civil Code, you would have to give written 24-hour notice each and every time you're going to enter the property. So hey, you want to show the property this weekend, Saturday, you're going to have to give 24-hour written notice to your tenant today that, hey, you're going to be showing the property. You want to go show the property next Tuesday, you'd have to do a written notice every time you do this. So the Civil Code made it easier and understood, and the law was written in a way for realtors, people selling their property. Hey, we give you this notice of sale. We could just give you oral notice that we're going to be showing the property and so forth. So listen, if you guys have issues with terminating the tenancy, you're contemplating doing that for dealing with a real estate sale, always a good idea to talk with competent landlords counsel to help you through that process, making sure everything's legal and so forth. If you're in the Bay Area, we're here to help you out. Our information's down below. If you guys got questions, comments, put them down below. I'll try to answer the questions to my best of my ability. Until next time, folks, I'll talk to you then. Thanks.